Hello and welcome to the third episode in our MCA Mini Series. In this episode, we are going to look at the role of the Court of Protection. What is it? What does it do? And when would we approach it? The Court of Protection does what the title suggests. It's there to protect. But it has a particular group of individuals in mind. Those who lack the relevant capacity to make decisions for themselves. The Court of Protection has various different roles, or as I like to think of it, hats. Let's take a look at some of them. Determining capacity. Sometimes we work with individuals where it really isn't clear whether they have capacity around a specific decision or not. It could be a range of factors impacting on our ability to identify this. But before we would approach the Court of Protection for assistance, we would need to have made sure we tried everything else first. Just some examples are ensuring we've used suitable communication aids, that those who know the individual best are involved if that's appropriate, and that we've worked jointly with other professionals. If we've tried everything and still require assistance, then the Court of Protection would look to determine capacity and may do this by appointing an independent assessor. Managing disputes. Unfortunately, there are times when there are disputes between professionals, family members and others in terms of whether or not an individual has capacity and what decision is considered to be in the individual's best interests. It is important that, again, we try everything else first to overcome these disputes prior to approaching the Court of Protection. Think about mediation, revisiting capacity assessments and best interest decisions, particularly if there's new information available which may impact upon these. The use of advocacy, don't forget, the individual is entitled to support as well as their family members. Where dispute remains, the Court of Protection will look over the case as a whole and identify the decision moving forward. They could issue court orders as part of this if needed. Section 21A challenges. Similar to the role of managing disputes are Section 21A challenges. These are when either the individual, their representative or another wishes to challenge a deprivation of liberty safeguard, known as a DOLS, that is in place. The individual may, for example, be shown objection to their care arrangements which amount to a deprivation of their liberty, or there may be a doubt over whether the arrangements are indeed in the individual's best interests. Again, it is important that professionals have closely followed the MCA process when determining that the deprivation is in best interests. If we've tried everything to support the individual or those challenging it on their behalf, and the challenge remains, then we need to approach the Court of Protection for them to oversee the case and determine if the arrangements are indeed in the individual's best interests, or if they identify something else which needs to be explored. Appointing deputyships. If an individual lacks capacity to appoint their own attorneys, then those wishing to be appointed can apply for this via the Court of Protection. They can request to be a deputy for health and welfare and/or property and finance. Whoever the court appoints has to complete annual reports outlining what decisions they've made for the individual and also declare what monies have been spent if they are a deputy for property and finance. The court does not make this decision lightly and closely consider each application and monitor those appointed. Authorising deprivations of liberty in the community. If an individual lacks capacity and is identified as being deprived of their liberty within the community, aka their own home or supported living accommodation, then those arrangements need to be authorised by the Court of Protection. But watch this space, as Liberty Protection Safeguards, also known as LPS, which is due to replace DOLS in April 2022, will remove the need for the Court of Protection to authorise deprivations in the community. It will instead fall to the responsible body. Some key things to remember about the Court of Protection. They are bound by the MCA too. All decisions they make must comply with the MCA and made using the best interest checklist. Unless it is a protected decision or a deprivation of liberty in the community, approaching the Court of Protection is a last resort. The Court of Protection looks to see if an individual's human rights are being infringed by circumstances or decisions made, so make sure you have considered this before going to court. You need to be clear on the reason why you're approaching the court and exactly what it is you're asking them to take action on. Don't forget to seek legal advice first. And make sure your practice has complied with the MCA. that all your paperwork is in place and completed accurately. The court is not shy about pointing out where errors have been made, so be warned. Thank you so much for watching. Remember to subscribe to our channel so you never miss an MCA Mini Series episode. See you all next time.